Good afternoon, everyone, and thank you for joining us on today's webinar. My name is Justin Navarro. I'm a bookkeeper here at Granite Veterinary Advisors and your host for today. I'm excited for today's webinar as it's all about exploring practice strategies for retaining top associates in a competitive market, navigating ownership transitions, other hot topics such as AI, and everyone's favorite, legal and HR risks. Please welcome today's presenters from our friends at Mandelbaum Barrett, Frank Custode, and Peter Tanella. Both Frank and Peter have a wealth of knowledge, and I couldn't think of a better duo to speak on today's topics. Thank you, Frank and Peter, for joining. For any questions, please feel free to drop them into the chat, and I'll have Frank and Peter have a chance to answer those throughout the presentation.
Great. Thanks, Justin. Thank you for the introduction. Good afternoon, everybody. Good to see everyone. Frank and I are really happy to be here with you. Before I go ahead and share my screen and share our PowerPoint, just a general overview. Justin mentioned we're going to touch on a couple things today. I know we're going to kind of condense it in an hour. Frank and one of our other partners just did a presentation last weekend down in Florida over 4 hours, taking what we're talking about today, we're going to squeeze it into an hour. So there's a lot of information. And like Justin said, you guys got any questions, feel free to reach out. And even after this, we can continue the conversation. We're going to touch on, like Justin mentioned, the state of like the marketplace right now. Retaining talent, that's a big issue that we deal with on a day-to-day basis. Managing HR and legal risk, with Frank is dealing with on a regular basis with our clients. And this, we're going to touch on some ownership transitions, whether to corporate or independent veterinarians. So with that, I'm going to go ahead and share my screen here. Let's see here. Bear with me on my technologies over here. Let's see. Okay. Share. All right. Everybody see that? Is that good, Justin? You see it on there?
Looks all good, Peter.
All right. All right. So good. Okay. So let's get into this. Here we go. All right. Just before we get into the presentation, just a little bit about our firm. We've been in the industry, myself in particular, about 15 years now. And the way we like to describe what we do for our clients, and we work with veterinary professionals across the country, from the cradle to the grave. And we take a 360-degree approach. So we're doing all different types of or addressing all different types of issues for our clients on a day-to-day basis. And we have our 360-degree platform that enables us to kind of come in as a specialist for a particular issue. So, and it's worked really well for our clients because majority of our clients are practice owners, and at the end of the day, they're running a business, and a business has all different types of legal issues. Like I said, I've been in the industry for about 15 years, working with, I'm fortunate enough to work with Granite and that team, as well as a lot of other professionals, on all different types of legal matters that our veterinary clients deal with on a day-to-day basis. Frank, you just want to touch on your experience?
Sure. I appreciate it. Thanks for everybody for making the time today. I've been an employment law practitioner for almost 25 years. I have to hesitate to say that because when I say 25 years, it makes me feel old, which I guess I am. But anyway, I regularly counsel employers and veterinary practices on day-to-day issues, and prepare handbooks and agreements, and also represent employers in litigation. As you will see later in the presentation, as an employment lawyer, I'm not the most fun person to hang around. And the reason why that is because employment lawyers are worst case scenario thinkers, right? Unfortunately, you could ask my wife about how much fun that is to hang around with on a weekend. But anyway, that's what today, when we talk about HR and legal risks, it's about trying to minimize liability so that we could help you navigate what is becoming an increasingly litigious workplace atmosphere. So we'll get to that a little bit later in the presentation, but again, appreciate your time.
Yeah. Thanks, Frank. All right, let's just talk about the marketplace just real quick. This slide is somewhat dated in a way. You look there at one point in time, there's 70 corporate owned consolidators. Probably out of the 70, maybe there was 100 at one point in time. We on a regular basis probably deal with the same 10 or 12 these days. And I always point to January of 2023 as like the mark when the pendulum kind of shifted. Back before January 2023, when we were in 22, 21, and 20, it was like the Wild West of corporate transactions, and there was a ton of different consolidators out there. That's kind of not kind of it's tightened quite a bit. In terms of multiples, I kind of just wanted to put in here, what we were seeing in 24, what we were seeing in 25. Year to date now, it's probably pretty similar to what we're seeing in 2025. We've had on the low end, you may have, 5 to 8, a multiple on the higher end, 11, even recently we've had 12, 13. It just really depends. It depends on the number of doctors that you have, the revenue that you have, and obviously the location where you have. Nothing earth shattering. All those factors play into it. And then whether or not you run a competitive process when you're looking to sell. One of the biggest issues that we deal with that kind of even backs into when you're looking to sell is retaining associates. I don't think a day goes by in our practice where we don't have an issue with one of our practice owners trying to retain associates. I could probably count on one hand the number of our practice owners who, when I ask them, well, how's it going with associates? Well, they're either not shorthanded or they have no issue retaining them. Most of our clients could always use another associate, and then others are just challenged by trying to retain top talent. Some of the things that we talk with our clients about, and then also associates about, what are the issues that you're seeing? Obviously, the ones who are successful retaining top talent, culture and values. Culture in this industry, what Frank and I have seen, I used to represent a lot of other different businesses before I got into the veterinary industry. And money is important to everybody. However, in this industry, I think money and culture go hand in hand. Whenever I'm talking with a client who's maybe even looking to sell their practice, yes, they're trying to get the top dollar amount for their practice, but they're also asking, well, how is that buyer going to treat my staff? What's the culture going to be like? What are their values like? You don't see that outside the veterinary industry when somebody's looking to sell a widget company. So it's really strong. And the practices that have really good culture and values, I find, are the ones that are really successful about retaining top talent. Not surprisingly, career growth and mentorship is another thing that goes hand in hand. We had an independent client recently. He was able to recruit away an associate from a corporate practice. The associate actually took less money in order to come to our client's practice because the associate knew that they were going to get the mentorship that they were looking for. So that's really important. And then I'm not telling you anything you don't know. Work-life balance. I think that's permeated in every industry. The veterinary industry in particular, work-life balance is very important. Ways that we talk with our clients about retaining top talent. These are really the three top ones that we talk with them about. Because a lot of our clients these days are saying, what can I do as a practice owner to entice my associate to stay? These three are the typical solutions that we talk with clients about: equity or phantom equity options, profit sharing, or true equity. Okay. I don't know if any of you are familiar with any of these, but these are typically what you know we talk with them about. And this is kind of a breakdown of what the three mechanisms are. I'll start with phantom equity. That's in the middle. Okay. So the reason phantom equity is there, most of our clients, the practices, they're taxed as S corporations, and there's obviously you work with Granite Peak. There's tax benefits to being an S corporation. The issue with being an S corporation, it prevents you from offering profit interests. So what we end up doing is we'll talk with our clients about, okay, why don't you put together some type of phantom equity plan for the associate? What is it? You're an associate, no, you have an associate, you put a plan in place, and basically the associate has the ability at some point in time to be rewarded in the event that there is an ownership change in the practice. If the practice gets sold in the future, the plan would include that the associate would get a percent or some percent of the sale price. They're treated like an owner, okay? Like an owner gets a piece of the purchase price. The reason it's called phantom equity is because all they have is a contract. They're not an owner. They need to be um, employed in good standing at the time of when the event takes place. If they leave or they're terminated, the benefit goes away, a la phantom equity. So you have phantom equity in the future proceeds of a sale, but if you're not there when that occurs, you don't get it. And you do this because most of them are taxed as an S corporation. If you're not an S corporation, and you're taxed as a partnership, then you have the ability to do either phantom equity or profit interest. Profit interest is actually real equity in the practice, and it's just another enticement that you can give to an associate that they can be rewarded in the future profits of the practice. You just can't do it if you're taxed as an S corp because you're limited as to in an S corporation, who can own interests in an S corporations. So you can't offer profit interest. And then I think I always look at the last resort is true equity. You know, is this person, is this associate, do you know them? Have they been working for you? Because once you know giving somebody or selling somebody equity, you're letting them into your home. And once they have equity and they're an owner in the practice, then they have certain rights that attach that they wouldn't as just as an employee. Um, we are probably, again, I'll go back to January 2023. We are probably working on more associate buy-ins than we have pre-COVID. When there was the boom in corporate sales going on, most of our clients weren't looking to sell down to their associates. Now with multiples tightening a little bit, what we see a lot of our owners are figuring out ways creatively to actually sell, equity to their associates. We are working on a number of those right now, which is great because it's a win for the practice owner because they're setting their associate up for success, and you've got a built-in succession plan. And it's great for the associate because they buy maybe 10% of the practice. There's a liquidity for the owner, and the associate, has a vested interest in the practice. Um, and then there's like transitioning. We like to talk with our clients, again, ways to entice the associates to stay, really trying to talk with them about the mindset. It's all about, from just being an associate to an owner mindset. And you as an owner having those conversations with them. From a salary to, profitability focus or individual like success versus team success. Um, some of our clients are, when they come to us and said, "Hey, I'm gonna offer to sell 10% or 25% to Dr. Smith. She's been with me for 5 years. She's been great." And then the really successful transitions that go on, Dr. Smith has been at the table with the owner, for a while now, and he or she has shared the financial metrics or the business performance, really providing mentorship and leadership for Dr. Smith to be successful as an owner and really feel vested in their practice. Any questions so far on any of that?
Looks
Okay.
none in the chat currently, but this is really good information. I have a question for you, Peter. In your experience with this, can you speak on the importance of going through legal? Because I feel like oftentimes, like whenever practice owners are wanting to come up with these creative ideas, oftentimes, it might just be trying to draft something up, like using nowadays using ChatGPT. Luckily, you have clients that come to you, but I'm sure that can get in a sticky situation. Yes.
Yeah, and Justin, it's a great point. Listen, the majority of our clients come to us now either using chat or Grok or some other Gronk or whatever it is, some other form of AI, which is great. I get it. But I always use the analogy, and I sound like a broken record because I was saying this to a client yesterday. If I came to your practice with my dog and my dog is scratching constantly, I don't know how to fix it. I'll go on Google and try to address it. That's not my job. I'm looking to you as the professional to say, here, these are your options. This is what's involved. Educate me in the issue. And then I, as the client, get a chance to make the choice. And it's very similar here. When our clients come to us, we want to give them the options. And then they make the decision at the end of the day. Just like I mentioned earlier, maybe it's profit interest. Maybe you do want to give them real equity. I might say, well, is that the right person to do that to? Or maybe you're thinking about giving somebody equity because a lot of our clients don't even understand or know about the phantom equity component. I have a client out west. He's got three practices, three separate locations, all under one S corporation. The gross revenue is probably about $8 million. No, he is probably like it's a corporate practice, a corporate target practice, right? But he's trying to figure out a way, if he can, to get ownership or get his associates who are really high, earners and producers vested in a practice. So what we did for him is we created a phantom equity plan so that his current associates and just like four really top producers that he has, they feel vested in it. There's no way he's going to go on a chat and figure out, first of all, that that's an option, and two, that's a plan that he can use. And then you try to do that, you run the risk of losing one of those associates, which he has, and why he came to us because he was a couple of his associates were getting cherry picked by corporate because corporate was throwing a lot more money and benefits at them. So he's like, okay, how do I fix that? How do I address that? Let's see here. So here, and then there's one other just quick slide for I turn it over to Frank, just from doctor to leader, kind of developing the leaders, expanding their perspective, helping them to understand the business side and the patient care side of the practice. This next one, like the build leadership skills, I think any practice owner will tell you, at least in my experience with all of our clients, when they first become a practice owner, there's no training like for communication skills or conflict resolution in veterinary school. And most of our clients tell me it takes a year or two for them to get those skills. Some of them are born with good communication skills, but a lot of them aren't. And it took them years really to develop those communication skills. One, communicating to the staff, and then two, communicating to the clients. And I think, a good practice owner helping, foster good leadership skills will result in a more rewarding outcome for the practice. And again, involving doctors in decision making, the ones that we see success with transitions have involved their associates in the decision making process, mentorship and coaching, and then this aligning the incentives with leadership growth through ownership or performance awards, either maybe a profit interest, a phantom equity, or a lot of times in our employment agreements, there'll even just be a discretionary bonus that can be provided on an annual basis. But obviously, it's a competitive market, and all of our, all of who are practice owners, it is competitive, and you're competing, against some of these corporate practices that are, maybe have the ability to pay more. So you're trying to figure out different ways for you to be strategic. And one other thing that came up recently too, and I know Frank heard this at the presentation he gave. Maybe being creative with the student loan and ways to maybe pay, offering, maybe not giving them a bonus outright, but maybe some type of way to pay down their student loan for them. Again, enticing them with some type of performance award. Okay, so with that, Frank, I'm gonna turn it over to you, Frank. I'm gonna drop off, stop sharing my screen, and you can hop in here. So let me get out of here. Let me
Got it.
see here. Yeah, I'm gonna stop. Can I do it? Nope. Bear with me. Let me see. Nope. Let me see.
I could tell we're not IT people.
Yeah,
Right
I'm struggling. Oh my
there.
God. Yeah, it's
Yeah.
embarrassing. Oh my gosh.
We all have
Uh,
our strengths.
yeah.
Yeah.
I didn't even know where's it say stop
Tech isn't
sharing the
well.
screen on this thing? I don't even know. Oh my gosh. Embarrassing. I didn't see it. Let me see. I don't see it.
Probably
Justin,
the
where are
share
you,
button.
buddy? Oh, there we go. I got it.
There we go.
Boom. I'm
Okay,
out.
All
there
right,
you
let me
go.
see. Well, let's
All
see if
right,
I
great.
could I can get it done for you here. Is it on?
Yes, we got it. And you've got
All
the
right,
the hot
cool.
topics here, Frank.
I've got the
You're
hot
not kidding.
topics. Yeah, no, I hear you. So yeah, this is the fun stuff now, right?
Yes.
Um, so listen, guys, this is we're gonna cram a lot into a little here. So I have no problem with um, questions, interruptions, etc. So to the extent you have any questions, feel free to just drop it in the chat or Justin could relay them to me.
Will do.
So this is piggybacking off what Peter just said. Um, like post COVID, the workplace has changed. There's no question about it. How employees interact with each other, where they work, how they view their jobs. Certainly, the workplace has become more litigious. A lot of calls I get from practice owners about how to deal with employees that either are raising complaints in the workplace. Maybe they have some sort of accommodations request that they're making, etc. So there is certainly a proliferation of litigation in the workplace. So really, what we're trying to do in a very condensed period of time today is kind of give you the top five risks, um, from a management standpoint and how to minimize those risks, right? So the first one is what hiring mistakes. But look, nobody bats 1,000 when they're hiring employees. I mean, if you hit 300, you're a Hall of Famer, right? So really, this portion of the presentation is to try to give you an idea on things that you have to avoid from a legal standpoint and things you have to do from a legal standpoint. Um, First one would be interview pitfalls. Many states prohibit employers about inquiring about an applicant's criminal background. Okay, so you need to be mindful of that. These are generally called ban the box laws. And the general rule of thumb is that you necessarily can't ask questions about criminal history in the job application process or the initial interview phase. But after an offer is been given, then obviously you can get consent to do a criminal background check. Some states that prohibit that are New Jersey, which is where we're located, Hawaii, and Massachusetts. Also, with salary history, um, many states enact salary history bans, making it illegal for employers to ask questions about current or past compensation. The goal here, from a legislative standpoint, is to make sure that hiring and compensation is based on objective job relevant criteria such as qualifications and the like. But what you can ask in a job interview are salary expectations. It's a subtle difference, but it's an important one to note. So you can't say to someone, "Hey, how much money are you making at company X or practice X?" But what you could say is, "What's your expectation on salary?" Right now, a lot of times in interviews, from a practical standpoint, people offer this up anyway. But you just need to be mindful of complying with the law. And some states that enact that are again New Jersey, Massachusetts, Maryland, Colorado, and of course California. Well, there's also a growing number of states that require salary disclosure in job postings, meaning you have to give a range of the salary or an estimate of the estimated compensation for the job. That's in Jersey and New York as well as other states. Other thing, it goes without saying, but I'll say this in today's economic and political climate, the Department of Homeland Security is absolutely cracking down on authorized individuals to work. I helped a client months ago that got audited by the Department of Homeland Security and ended up having to fire longtime employees that unfortunately weren't authorized to work in the country. So it's very important to not only have I-9 verification, but to make sure your employees update their I-9 verification and have it handy in the event of, have the relevant documents handy in the event of an audit. And to, as an employer, a good tool is something called E-Verify, which is a pretty easy way for you to make sure that you're compliant with I-9 verification. And of course, it goes without saying, but I'll say it again. I'll say it initially, I should say, is, you don't want to ask questions about protected categories on an interview, right? Somebody walks in and they're, a little older, you don't want to make a comment about their age. If somebody walks in and they look to be pregnant, you don't want to ask if they're pregnant. If you don't end up hiring that person, unfortunately, they could give rise to something called a failure to hire claim. So you're just going to be very mindful of having a very, generic conversation with people. But listen, your goal on an interview is obviously to communicate expectations, learn about the candidate, try to see if the candidate is a match for your culture. And of course, it's best practices just to be prepared, know what you want to achieve during the process. And again, don't beat yourself up because nobody is going to bat 1,000 in interviewing, right? Now you've hired the person. You got to figure out now how to document, right? And another risk is what we're calling weak employment documentation. Every employee that you hire should get an offer letter, okay? Regardless of it's the front desk receptionist or an associate, vet. You're going to want to memorialize the terms at a minimum in an offer letter. The type of things you put in the offer letter, obviously, are compensation, whether the employee, their job responsibilities and title, whether the employee is exempt or non-exempt under the Fair Labor Standards Act and applicable law. That goes to whether or not the employee is going to be eligible for overtime. Obviously the compensation, and you're going to want to make clear, probably the most important part from a legal standpoint, is you're going to want to make clear that the employment is at will, meaning it could be terminated with or without cause and with or without reason at any time by not only the practice, but by the employee.
Frank, the one exception to that, Frank, and I'm not to jump ahead, but if you're an associate and you want to hire, what's your thought?
Yeah.
You're going to address this about, bringing an associate in for like a 1-year term, something along those lines.
So that goes to, typically an associate is going to have the terms and conditions of their employment memorialized in the employment agreement, right?
Okay.
And it usually, Peter's obviously correct, usually for a vet, you're going to want to have a term. The offer letter is really going to be mostly for the non-managerial staff employees. But, in an employment agreement, we're jumping ahead a little, but it's fine. In an employment agreement, one of the more important things is going to be the term and how you terminate the agreement, either by the practice or by the employee. And you as a practice owner you have to weigh, patient continuity versus your ability to immediately terminate an agreement, right? So you could have an employment agreement that has a completely at will relationship, meaning it gives either side the ability to terminate the agreement anytime they want without cause. You could have an employment agreement that has a specified term and requires the employee to give notice for a specific period of time, or you could have it so that the practice would give a certain period of time of notice, maybe like 30 days if they want to terminate without cause, and a more elongated period of time for the employee to give notice, maybe 60 days, maybe it's 90 days, maybe it's 120 days. So certainly, yeah, that's one of the things you're going to want to cover in the employment agreement, which leads to my next point. So mostly for associate vets, but listen, if you're hiring management level employees, whether it be a chief financial officer or a CEO, depending on the size of your practice, it's a good idea to have the terms set forth in an employment agreement. You're going to want to list out the compensation, job duties, and the responsibilities. Again, how to terminate the agreement. Almost all employment agreements have something called a termination for cause, which allows the employer to immediately terminate based on certain wrongful conduct of the employee most of the time, whether it be commission of a crime, not being licensed if they're a vet, material breach of the agreement. There's going to be termination without cause, like I just indicated, or you could have literally a true at-will employment relationship. Sometimes these agreements will say at-will, but then they have notice requirements. So it's not really a true at-will relationship. You want to make sure that you clearly define how to terminate the agreement.
Frank, let me just interject real quick. Two
Yeah,
points.
please.
Wait, going back to Justin's initial point, when he asked me, what Frank's talking about these employment agreements and whether it's, a term at will or maybe the practice has the ability to terminate, but the associate doesn't. That is all around a consultation, a conversation with your lawyer. That's why, you can go on chat and you can find these things. But to Justin, to answer your question earlier, again, here and it follows through what we're talking with our clients about. Like what's, what's the success that they've had with their associates? Do they need a term in here? Why do I want a term? Maybe it doesn't apply to me, but it's a conversation. It's not a one size fits all in that sense. And depending on what hat we wear, now, a lot of times we're representing the practice owner. We want to have a wide variety of ways we can terminate for cause. You want to throw the kitchen sink in there because you want to be able to terminate that associate, as in the event that it's just not working out. If we're wearing the hat and representing the associate, obviously we're focusing in on those termination for cause provisions, and we're trying to cherry pick. Well, maybe we don't want them to be able to terminate. You're trying to kind of chip away at that and minimize the way the practice owner can terminate you for cause. So, just two thoughts. Go ahead, Frank.
No,
Thank you for that.
100%.
Oh, Frank, hold on. You got a question in the chat, Frank.
Yes. So
So
we have
can
a
you?
question
Yeah.
here. So can you have an at-will and a notice in an employment agreement?
You can, but I mean it erodes the at-will nature of the employment. So typically you could say you're at will, but you're essentially defining at will by requiring the allowing the practice to essentially terminate at any time, but also but imposing notice requirements on the practice. I don't know that I would necessarily use the word at will, but I mean what you sometimes what we do is we'll say termination for convenience or without cause, meaning and we'll put that the employer could terminate at any time without cause upon written notice, whereas the associate has to give 30, 60, 90 days notice.
Frank, those are the type I'm laughing because those type of agreements, Justin, come across our desk. Usually our client, will come to us. Well, I kind of put this together. I did it myself. That's when and then they're coming to us, and then we're kind of either revising or we're putting a new one in place. But Frank, when you say most of our time, when you see that contradictory language, it's usually because they kind of went on Google, they did it themselves, and they're coming to us afterwards.
Yep. And I have plenty of
Yeah.
practice owners who've came to me and said, listen, I want to terminate this person. They don't necessarily have a for cause reason. And the agreement will say like that you have to provide 30 days notice. So then
Yeah.
we're trying to figure out if we could, pigeonhole the conduct into a for cause reason, you know.
Yep.
And likewise, if you're representing the associate and there's not an adequate for cause reason, it gives the associate a basis to challenge the whether the agreement's been breached.
And not to beat a dead horse, but we're joking, we're laughing a little bit about it. But just think about it. If you're looking to terminate somebody as a practice owner, you just want to get that person out of there. And then to find out that maybe I got to wait 30 days or this person has some rights I wasn't aware of. That's why you want to spend the time to do it right the first time. So then you have the ability. If it doesn't work out, you can move on and have that person removed.
Right. And even if you have a notice period in, right, if it says that the employer has to provide 30 days notice, you could put into the agreement payment in lieu of notice if you wanted to jettison the person. But I find with practice owners, it's kind of a fine line because sometimes they do, depending on the associate's conduct, want to get them out of there ASAP. But a lot of times it's, there's a concern because there's a transition issue with the patients, right? And they want them to stay on and be able to provide the services and transition to another provider with the practice. So it's a fine line, and Peter's 100% correct in the sense that it's definitely a fluid discussion that you would have with counsel when you're preparing the agreement. Moving on to the next point, job descriptions. Whether it's in the offer letter, in the employment agreement, or a separate document, they're important. Why are they important? It's really a guidepost for the employment relationship. Okay, meaning, if you fast forward and you want to terminate someone for performance, and you're saying they're not adequately performing the job duties and responsibilities, it's helpful to have something in writing that you could point to say, hey, you're supposed to do A through Z, and you're only doing A through E satisfactory. So it's important in that regard. It's also important if, heaven forbid, you have a problem with the Department of Labor with a misclassification issue about whether or not you're an independent contractor, whether the worker is an independent contractor versus an employee. The job description, while not dispositive, could shed light on that issue because it'll help determine what the parameters of the job responsibilities are. Okay, so it is important to have clearly defined job descriptions. The other thing that comes up many times in employment agreements, and again, this is another fluid discussion, it depends on, frankly, what you want to do as a practice owner, is whether to include restrictive covenants in the employment agreement and what type of restrictive covenants that you'd
We
want
could
to
do a whole
include.
webinar just on this topic alone,
Yeah,
Frank, based upon
yeah,
what's gone on. Right.
100%. So the three basic restrictive covenants are non-competes, what's known as non-solicitation provisions, and non-disclosure provisions. A non-compete is a provision that essentially prohibits the employee from joining another practice within a certain time and geographical radius. Courts look at them, generally speaking, on whether or not they're protecting the practice's business interests, whether or not they impose an undue hardship on the employee, and whether or not they're injurious to the public. The undue hardship analysis really comes down to time and geographical scope. Generally speaking, 2 years or less is acceptable. And the scope that I usually see is under 10 miles, right? I'd say somewhere between 5 and 10 miles.
And Frank, the scope you're talking about is more for a general practice. For our specialty practice owners,
Mhm.
you can have a much larger scope because obviously the client's coming from a larger radius. A lot of times we'll get referrals over for people who associates work at like Blue Pearl, for example. And Blue Pearl is, known for 50-mile radius, around the practice. But it's a reasonableness standard. And if you're pulling clients in as a specialist, 10, 20, 30 miles. I mean, again, to put Frank's point, it's a conversation that has to be had. And the only other thing I'll mention on the non-compete too is, over the last, I'd say 2 or 3 years, what we've seen, there's a lot of chatter in the industry how non-compete should go away. And I think, Frank, it was back in January, 2 years ago, maybe the FTC came up with that ruling
Yep.
that kind of sent, shockwaves through every industry. It's on a case by case basis. It really is. And there's a conversation to be had about it, depending on what state you're in and what you want to do. And I think it goes back to talking to your attorney about, what fits your practice rather than painting a broad brush and saying, I don't want to have them, they're no good, or something along those lines. We're like Switzerland. We're in the middle, and we're here to advise you. We're not a proponent one way or the other, but we also you want to be properly advised. So in the event that you do look to do some type of sale down the road, you understand maybe the ramifications of not having a non-compete in place. But I mean, again, it's part of a conversation. So go ahead, Frank.
Yep. No, and I have practice owners that don't want non-competes in their agreement. Some of them, they think it's a detriment to recruiting. They don't want to saddle the associate with non-compete obligations. Others are adamant about it, right? They want it in there. And then to Peter's point, look, sometimes like I've had practice owners that are in like rural areas and say, look, I need a larger radius than 5 to 10 miles, and it's justified because I'm in the middle of state X, and it's there's nothing around me. So
And Frank and Peter,
it's yeah.
we have two questions here in the chat. One of them is, what if
Sure.
someone does not disclose their protected class prior to hire, but then can't perform all duties of the job once hired because of their restrictions?
Yeah, it's a good question, and it's a very practical and real life example. So look, I mean, most people are not going to, disclose anything that they could view as detrimental to their chances of getting a job. But like I said, nobody bats 1,000. So as a practice owner, you have to address that, and typically the way that that's addressed is by engaging in dialogue with the employee regarding a disabilities accommodations analysis, right? Which it's legal mumbo jumbo, but it essentially is called the interactive process, which is just a fancy word for dialogue about whether or not the person can perform the essential functions of their job, with or without a reasonable accommodation. I mean, when I presented a couple of weeks ago, a practice owner told me that they had a front desk receptionist that had a hearing issue. That's a tough one to accommodate, right? Or a medical assistant. Another one came up, a medical assistant that was allergic to cats, that works for a vet. But look, you're still obligated, even if you think it's not feasible, to engage in that process under the law and have that dialogue with your employees and determine whether or not there's something there that you can do to help them. And if not, to have a legitimate bona fide basis for saying that this would cause an undue hardship. And undue hardship is essentially a financial difficulty or something that would be a significant impediment to the practice's business operations.
And then going back to non-competes, we had a question as well about certain states where it's illegal, specifically New York. Do you happen to know a list of states where these non-competes are illegal?
Yeah, it's not illegal in New York. There's a couple states that ban them specifically against vets. I know that Maryland is one and Maine is another. But it's state specific. Most of the time, though, they're enforceable.
Frank, it's state specific, right? And then what we're seeing, even going back to, when you were talking earlier about, I heard, on the like interview pitfalls and salary disclosures in the regulatory environment, right? It's constantly changing. And I know you're going to talk about handbooks at some point. The regulatory environment is constantly changing
Yeah.
too. It's very fluid. So we're looking at it on a regular basis, Justin. So you say, what states? Yeah, right now these are the states, but then in other aspects, it changes on a periodic basis.
Changes. It could change by the month.
Yeah.
So that it's, it's very state specific, and you have to, our recommendation obviously would be to consult with legal counsel on an issue like that, to get the latest trends. Um, all right. So I'm going to try to go a little bit quicker.
Yeah, we got a lot to cram in. And Justin, are we tight on flow? 1 o'clock. It's a tight time
We
frame.
have about 9 minutes, so
Okay.
whatever we
All
can
right.
squeeze in there.
So
All
Frank,
right.
you go through yours, and
Yeah.
then we could probably just take some questions, and we could always
Yeah.
share the PowerPoint with everybody.
So yeah, just real quick on. So now you've hired the employee. They've either got an offer letter or an employment agreement. They're starting. Some essentials that you want to have, right, to minimize risk. You want to have a handbook, okay, regardless of size. It gives their employees, your employees notice of employers of your policies and procedures, sets the tone for what you're hoping is a professional atmosphere, and most importantly, it could be an affirmative defense in litigation regarding discrimination or harassment, because any good handbook is going to have an elaborate anti-discrimination and anti-harassment policy that has a complaint mechanism that allows employees to voice any concerns they have about discrimination, harassment, and retaliation.
And I would just say that you want to have legal counsel. We're attorneys. We want you to have your attorney review that or draft that for you. And we draft them regularly for our clients, because a lot of times when you have these payroll companies out there and they're pushing out these handbooks, I mean, when you need it, it doesn't work for you. So like the old saying, you get what you pay for. It definitely think, and they are those rules and regulations are changing on a regular basis too, depending on what state you're in. So you really got to be careful, and you should have counsel review that with you.
Yep, probably annually.
Yep.
Really, I mean, you do a handbook. I mean, I have people that come to me sometimes with handbooks that are 8 years old. Thing needs to be completely redone because the laws have changed. But yeah, you're going to want to have a handbook. I'm not going to go into great detail about it, considering the time restraints. But just having a handbook is not enough, right? Like if you don't implement the policies and follow them, the handbook is essentially meaningless. So it's not only just having the handbook, it's making sure that you administer and implement the policies that are set forth in the handbook. Another thing you're going to want to do, and in some states they require it annually. New York is one of them. You're going to have, anti-harassment and discrimination training, right? It supports better communication in the workplace. It's good for morale. It shows employees that you're taking these issues seriously, and most importantly, it's risk management. There's a bunch of online courses that you could buy that use vendors for. We as attorneys could do training. Sometimes clients want in-person training, but the bottom line is you want to have training. You want to make sure that it's memorialized, that the person actually it received the training, that the employees receive the training, and it's good practices. In terms of documentation, this is a big one, something that a lot of small employers neglect. If an employee is struggling in the workplace, you need to memorialize it and have dialogue with the employee about it. Most of the time, this is in the form of performance evaluations. It's incredibly uncomfortable sometimes for supervisors or practice owners. I mean, we're all people. It's hard to, a lot of people don't like confrontation. Even as an attorney, I don't like confrontation, believe it or not. But it's just an unfortunate part about being a business owner. They're not teaching you this in vet school, but there's something called the halo effect, meaning, in order to appease people, you're giving them non reality based feedback, right? But then what ends up happening is, you call me up and you say, I want to fire this person, and you're saying it's performance related, and there's nothing to back it up from a documentary standpoint. So it's very, very important to make sure that, as painful as it is, that you're honest with employees, and that you give them, real feedback that could help them. The employee could participate in the process. It should be in writing. Give them an opportunity to raise any concerns that they may have. You could ask them to acknowledge it. Sometimes they, sign and acknowledge. Sometimes they won't if they disagree. That's fine too. You could just write employee refuse to sign. but it's very important, because heaven forbid, if you're ever involved in litigation over a wrongful termination, many times it's going to go down to whether or not you had a legitimate non-discriminatory or non-retaliatory basis for the decision. And if it's documented, it's certainly going to help, right?
Right. Could you just send yourself an email to, like, I spoke with Dr. Smith today about this particular issue, because then it's got the time in there, it's
Yep,
got the date in there, and then boom, you put it in the file. So you have it. You have
yep,
something in
yep.
that along
There's
those
something.
lines. Yeah.
Yep, yep. There should be something. Absolutely. That's fine. Risk number 4 is discipline and exposure. Same kind of issues we're talking about from a termination standpoint. Look, a lot of companies have something called progressive discipline. That's really taking a progressive disciplinary action depending on the issue. It could be verbal first, then it's in writing, and something called a performance improvement plan. There might be some sort of training, all the steps before termination. If you have progressive discipline, you're going to want to make sure that it still gives you the ability in a policy to terminate the employee without going through the progressive disciplinary process. So that's important. Documentation. If you're going to let somebody go, you have to make sure that it's documented properly. There should be a termination letter. You don't necessarily have to put why in a termination letter unless it's an associate and it's a for-cause termination. In that case, you would want to put why, so that there's an adequate factual basis for the for-cause termination. Then we get to ending the employment relationship, right? Which again, this is dialogue with counsel before you fire somebody. First, you're looking at the employee at issue, right? You're analyzing them. You're troubleshooting potential issues. Is there is this person complained about anything in the workplace? How old are they? What's their demographic? What protected classes are they in? Learning about the person's personality too. What kind of personality does this person have? Are they potentially litigious, right? Analyzing the basis for the termination, what we just talked about. Is there a adequate documented basis for whatever decision you are making? If you are eliminating a position because of financial difficulty, can you prove that through your financial statements? If it's performance based, do you have documentation, whether it be a performance evaluation or otherwise, to show that you've talked to this person about their performance deficiencies, right? Administering the termination, very difficult. Many employers, especially smaller ones, have difficulty with this. You should assume that you're being recorded if you're firing someone. In many states, it's a one-party consent state, meaning the person being fired could be recording you, and they don't have to tell you that they're recording you. So the most common question that an employee asks when there's a termination is why, right? Why? And you don't necessarily have to answer that, right? If the employee's at will. Usually what I'll tell an employer is say, look, we don't necessarily think it'd be productive to get into a back and forth as to why. Just understand that, the decision is final, and we wish you the best. You're going to want to have a witness in there. You're going to want to make sure you get your stuff back, right? I just helped an employer get their laptop back from an employee they fired from last July, because the employee was keeping it because they didn't want to pay for the shipping costs. Separation agreements. In addition to a termination letter, right? It's a business. We're running out of time, but this is an important one. It's a business decision on whether or not you want to offer someone separation pay, right? The question I get frequently, right? The reason why people are calling me is they don't want to get sued, right? We're going to fire this person, but we don't want to get sued. The only way you could assure that you will not get sued is if the person signs something called the general release, which is included in a separation agreement. So the concept is you're paying the former employee some sort of monies they otherwise wouldn't be entitled to, among other things, get a release from that employee that they won't sue you, right? There's typically confidentiality in there. There's non-disparagement language in there. There's non-admission of liability, meaning, just because you're paying them doesn't mean you're doing anything wrong. It's a very good investment. It's one that I almost always recommend, unless there's real concern that the person's going to fly off the handle, and it might embolden them to go speak to a lawyer when you already expect they're going to. But 9 out of 10 times, I'm going to recommend separation agreement, right? And then lastly, um, risk number 5, litigation cost insurance. First question, if you get nothing else out of this seminar, it should be, do you have employment practices liability insurance, right? It's like any other form of insurance that you would have. If an employee threatens to sue you, you would be covered under this insurance policy, right? You'd have to pay a premium and a deductible like any other policy, and you'd have a limit on coverage. But it's a big peace of mind. Many clients do not have it, but it's usually the first question that I'll ask when there's some sort of threat in litigation. Could be a tremendous cost savings. I'm not suggesting that the insurance is inexpensive, but when you weigh it against potential litigation costs, you're usually coming out ahead.
Frank, I just want to emphasize that point. I know we're running
Yeah.
out of time. We could probably wrap up. For anybody who's a practice owner on this call right now, one thing you take away, you should call up your insurance agent or send him or her an email. Hey, do I have EPLI? And if you don't, you should inquire about it. It's that important. I can't emphasize that enough.
Thank you so much, Peter and Frank, for all this valuable information. There's definitely a lot of takeaways that I feel like our clients and our friends can take from this presentation. So thank you so much. Everyone, thank you for joining us today, and please join us on our July webinar on Wednesday, July 8th, where we will be talking with Butler Vet Insurance. Thank you again to our friends at Mandelbaum Barrett, and I hope you all have a great day.